Welcome to another in a series of NJAPM webinars. The title for today's webinar is Social Security Information for Family Mediators, and the presenter is Gabrielle Strich. Gabrielle is an attorney and a mediator. She started her mediator career by completing a 40-hour mediation training course given by the Institute of Dispute Resolution of Seton Hall University of Law in November of 1995. Gabrielle has served as a member of the board of directors of NJAPM and its president from 2018 to 2020. And interestingly, Gabrielle formed the Central Jersey Princeton Mediation Consultation Group in 1997. So with respect to questions, Gabrielle will be taking questions as her presentation goes along. If you want to ask a question, please either raise your hand or put it in Q&A, and I will be handling questions for Gabrielle. And with that, welcome, Gabrielle, and it's over to you.
I'm going to go ahead and share my screen.
Yes.
Thank you. Can you see the screen?
Yes.
Okay, the problem is I can't make it bigger because all right. So hello, everyone. Welcome. There are 2,700 Social Security regulations, and I do not know all of them. I have been busily trying to learn as many of them as I can, and I hope that you will find this conversation we're having very informative. So how do they know whether you're eligible for Social Security? You have to have at least 1.5 years of work to be eligible for Social Security disability, commonly referred to as SSD. You get Medicare after you're already on Social Security disability for 2 years. And this is important. This has come up in a number of my mediation and litigation cases where one of the parties is disabled. And the first thing you need to learn is, will they qualify for SSI or SSD? SSD requires a working history in which the party contributed to Social Security. SSI is that they don't have enough of a working history, but they're still meet the disability requirements of Social Security. Social Security takes the last 35 working years. Isn't that an amazing amount of years? And they index it, so the old years are in today's dollars, and that's how they calculate your Social Security benefit. You need 40 credits or 10 years of working to be eligible for Social Security retirement, unlike the amount of time required to be eligible for SSD. And every $1,220 equals 1 credit with a max of 4 credits per year. And you should tell your clients to, if they haven't set up an account, that they should do so immediately. And they just go to www.ssa.gov, my account, and you can do that as early as 18 years old. And you can watch and check that the records are consistent with what you think they should be. So for example, if you have a year where there's no earnings showing, you want to check that that's correct. And you can even do it in today's world, your mobile device. So who's on Social Security today? 65 million people. 8.6 million are on Social Security disability. 4.4 people are widowed and getting widow's benefit, which is your full spouse's benefit or your own, whichever is higher. There's 1.9 million on Social Security because of a parent being deceased before they turn 18. 1/3 of seniors rely on Social Security for 90% of their income. And that's a pretty scary number. Okay, so you can see, here's a chart as to when you reach what's called full Social Security retirement age. So depending on your age, and I got to come up a little bit so you can see more. one of the issues that when your parties are getting divorced and they want to know what kind of income they will have in retirement, this is one of the things you need to know. And as you know, the 2014 change to the regulations on divorce, particularly alimony, provides that there's a presumption that retirement at full Social Security retirement age, and these are the ages right here, that is presumed to be appropriate for retirement. It's good cause just to reach that age. So that's important for you to know these ages and that clause. Well, what if you want to take Social Security earlier? And what are some of the reasons that you might want to take Social Security earlier? Well, let's say you're just not making it. You don't have your client in question does not make enough money to make ends meet. Can they get Social Security? So the first principle we need to focus on is they must be married 10 years to qualify for their spouse's Social Security benefits, called a spousal benefit. You cannot have remarried or you're no longer qualified for from your divorced spouse's benefit. If you are divorced, you may take Social Security as early as age 62, spousal share, and you can wait until you turn 70, and then you can take your own full retirement that has increased 8% per year all this time. So that, where else are you going to get an 8% guaranteed increase in benefit? Nowhere, trust me. So that's a very important thing to keep in mind when you're working on a settlement. Well, if it's not relating specifically to divorce and they just can't make it, they need some money. Some people have taken Social Security as early as age 62, but there are really substantial consequences to doing that. That means you're taking a 25% decrease in your benefit for life. And also any income, we'll be talking about income that you earn until your full Social Security retirement age, that will have an impact on your Social Security, and it may or may not make sense. Another person that might want to take Social Security early is someone that is really well off. Well, why is that? They don't need the money. That's the point. They don't need the money. So they can take that Social Security money and they can use it for charitable contributions. They can do good and get a tax benefit on their taxes. So it's a double whammy for the good. So you might not even have realized that that could be a planning technique. So let's say someone decides to take Social Security at age 62. Well, and they're the higher earning spouse. Well, that's going to permanently impact the spousal benefit, because the spousal benefit is based on 1/2 of the spouse's Social Security, either from the date they took it, if it's before full retirement age, or the full retirement age amount. Now, if the spouse doesn't take their Social Security until age 70, the spousal benefit will not share in the 8% increase going beyond full Social Security retirement age. Okay. So here we need to talk about something to consider if you're thinking about taking Social Security early, or one of your clients is, more importantly. So if you take it early, if you can earn up to $17,640 with no penalty, but any amount earned over that, they will reduce your Social Security by $1 for every $2 earned. In the year that the client enters will have full retirement age. If they just start, let's say you're going to qualify in March because that's when your birthday is, and you want to take it in January, then you can earn up to $41,880 or $3,490 a month, and there will be a penalty of $1 for every $3 earned until you reach full Social Security age. Okay, so once you reach full retirement age, and if you want to then go ahead and take Social Security, you literally could make $1 million a year, and there will be no reduction on your Social Security. There will be taxes, but we will talk about that later. Okay, certain things are earned income and certain things are not included as income. And you'll be happy to know that winning the lottery will not impact your Social Security. Okay. So we talked a lot about spousal benefits. Let's talk some more about that because that's going to be so important to family mediators. So as I stated before, you have to be married 10 years or more to qualify for spousal benefits. But what if the higher earning spouse has been married 3 times? Well, if each time was 10 years or more, then literally 3 of the ex-spouses in that example can get a spousal share based on the same husband, the same person or wife, as the case may be. And it does not, getting a spousal share, a lot of people don't realize it. They get very nervous when they hear spousal share. It does not, N-O-T, impact the spouse that they're using to get their spousal share. Their benefit is not impacted by anyone taking a spousal share. Okay, survivor benefits work a little differently. So remember I said if you're divorced, you can take it as early as age 62, but you have to be divorced at least 2 years. Okay. And let's say you were married over 10 years and you get remarried, but the remarriage is after age 60, then you can still qualify for a widow benefit. But it depends which husband has more of a benefit, or spouse, I should say spouse, not husband. I mean, obviously in the real world, men tend to earn more than women, but of course there are many exceptions, and let's hope that it is not the norm down the road. Children get benefits too, and we need to take this into account when we're looking at child support. It does go into other income on the child support schedule if the child is getting a child benefit because one of their parents died or is disabled. So let's assume the parent's disabled. When you're calculating child support, very commonly, if they're getting Social Security disability, which is a little more than SSI, but either one, if they're getting either one, their child is entitled to some benefits up to age 18. And commonly, those benefits will wipe out a child support obligation. So that's very important to know when you're doing those calculations. Okay. Now, you can still do what's called the start, stop, start strategy. What do I mean by that? Well, once you're age 62, you're eligible to take Social Security. So let's say, for example, one of your clients will be eligible for pension at age 65. Okay. But they need their Social Security now. What they can do is they can elect to take their Social Security at age 62. And then when they get their pension benefit at 65, they can stop their Social Security. Many people don't realize this, and not resume it till as late as 70, which reminds me, I had a client come see me. She's still working. She's got a professional job, and I'm doing estate and elder law planning for her, which I also do. And I start asking about her income, and I ask her about her Social Security income. She says, "Oh, I haven't taken it yet." I was so upset for her. She lost 2 years of benefits. I made her promise that she would apply for Social Security as soon as she left for my office and request 6 months retroactive benefits, which you are entitled to do. So that's another important thing to know that may impact your clients. And you will get an increase in your Social Security amount for waiting till you're 70, even if you took some earlier. So that's a good thing to know about. But if your benefits are suspended, then your spouse cannot get benefits until you're receiving again. In addition, let's say someone that took benefits and then they learned all this information that's in this seminar or webinar, and they're like, "Oh, that's a mistake. I don't want to take my benefits." If it's within a year of when they started, they can call Social Security and say, "I made a mistake. Do not send me any more," and they can refund the amount they have, and it'll be as if it never happened. You can do this once. Okay. Now, obviously, you want to minimize taxes. If your only income is Social Security, you're unlikely to owe taxes on that. But if you have the following income, you'd be surprised what's included to calculate your tax on your Social Security. You have non-taxable interest like municipal bonds or US savings bonds. So isn't that a surprise? That's not included as income on your tax return, but it is to calculate tax for Social Security purposes. Of course, your taxable pension payments, your dividends, your taxable interest, your withdrawals from any kind of retirement account, 401k, IRA, etc., except for a Roth IRA, that's separate. So if half of that total income calculated for Social Security purposes is more than 25% for an individual or 32,000 for a couple, then you have to pay tax up to 50% on your Social Security. So if you get 20,000 a year in Social Security, and these all add up to more than 25,000 for an individual or 34,000 for a couple, then you will pay tax on 50% of your Social Security benefit. If your income is greater than 34,000 for individuals or 44,000 for couples, then you'll have to pay tax up to 85% of your Social Security. And this is really common, especially if you're still working when you start collecting Social Security. As I said before, Roth IRAs don't count. You can, let's say you want your Social Security to increase 8% per year for life. So, but you want to retire. Well, you can draw down from your retirement assets and wait to take Social Security till age 70. Now, when I say age 70, I really mean that you should be applying 3 months in advance of whatever age you want to start receiving Social Security. You need to be further aware that, let's say your birthday is August. And so you call 3 months before that, you answer all the questions, you set it up that you're going to get Social Security for your birthday in August. The first payment is not August, it's September. It's always 1 month behind. Okay. You can elect to have Social Security take taxes out. And there's a form you have to fill out and send in between 7 and 25%. Now, some states even tax Social Security separate from federal tax, but New Jersey, for a change, is not one of them so far. So how much Social Security are your clients going to get? Well, there may be an annual cost of living There was 1.7% in 2015. It's supposed to be 3.7% for 2022, which is the highest increase in like 20 years. So, and there were many years when inflation was incredibly low, there was no increase whatsoever. Again, something to keep in mind when you're helping your clients figure out how is this all going to work in a divorce. Of course, in a perfect world, you should not rely on Social Security alone, though, as we know, 90%, a very high percent, do rely on Social Security alone. Okay. Well, one concern that we all have is that allegedly the Social Security fund is going to be wiped out by 2033. And if that happens, everybody's Social Security benefit would be cut by 23%. But older people do vote. So hopefully Congress is going to be smart enough not to let that happen. But since they can't seem to get much done, I'm a little nervous about that. So when should your clients or you take Social Security? And of course, the answer is it depends. It depends on your financial circumstances, your health. I mean, I had a person that came in to see me to do estate planning, and he had $3 million in IRA monies. And he didn't want his children who were in college to get that money outright. He just didn't feel they would know how to use that kind of money sensibly. In fact, I have yet to see a person in their early 20s get a large sum of money and not buy a new car. And it's not a used Honda they buy. They buy Corvettes and Porsches and other cars that may not be the best use of money to an older person. So, you know, in this case, the person I'm talking about, he had a bad heart condition, and I was so worried that I would not be able to finish his estate planning and his trust before he died on me. Well, ironically, he's still living, but he was in the hospital 3 times just while I was drafting this trust. And you should be also aware that there's this thing called the Secure Act, and it provides that anyone that gets retirement monies, and I don't mean Social Security in this case, must cash them in within 10 years. A spouse is an exception, and pay tax. So we used to do many trusts where we would put retirement monies in escrow, and the intention was to spread out the monies for a lifetime for your child. That's no longer possible. You can put it in trust, but the executor or trustee actually will need to cash it out by the 10th year and figure out the most effective way to do it, whether so much per year, whatever. That doesn't mean it has to be dispersed, but taxes will be payable, and trusts are at the highest tax bracket, something to keep in mind. Okay, so that went a lot faster because I was expecting lots of questions and I didn't get any. So as you can see, another thing you need to know. Oh, Joan Geiger has a question. She raised her hand, Carl.
I don't see that.
Oh, what can I do?
Hold on a minute.
All right.
Hold on. Okay, I do see it.
Okay.
Joan, unmute yourself and ask your question.
Can you hear me now?
I can.
Okay. So, and Gabrielle, I don't necessarily expect you to know the answer to this question, but I'm curious. If you have a state pension coming in, a New Jersey state pension, a TPAF, a FERT, whatever it is, does that count as income in terms of earnings for your ability to earn up to $17,600 a year?
Yes, it does.
Okay.
It's taxable too.
We do have a few comments. So let me read the
Okay.
comments and then we'll go back to some other questions. The first one is from Mitchie, who says, it's actually your top 35 highest earning years that go into the benefit, not just any 35 years or the first 35 years. It's
Well,
the
that's,
highest.
thank you for that clarification. I appreciate it.
Okay. And Jay has two. First is U.S. savings bonds may be taxed on the tax return each year or may be fully taxable when the bonds mature. It's an election by the taxpayer. Okay.
True, but who would think that income that is not taxable is included in the calculation for Social Security purposes? That was surprising to me.
Okay. And comment, you have not discussed the Social Security benefits due when the couple has a disabled child.
Right. A disabled child will get, and that's, again, those benefits will have to be taken into account for purposes of who the residential parent is, and it will impact the calculation of child support.
Okay. Now, let me go back. Let me ask a few questions. You talked about this 8% increase from the time of when full retirement age to age 70. I think that's only available now if you were born before a certain date. I think that was changed in 2015.
Oh.
And that it's only available to people who were born, what was it, before 1954, something like that.
I don't think so.
That's something my wife and I did, but we were clearly born before 1954. So yes, if you were born before January 2nd, 1954, that file and suspend feature is not available anymore, but it is for younger people. Another is, I think you can file for Social Security 4 months in advance. I think you said 3, but I don't
Well,
know.
I didn't say that you had to do it at 3, but I recommend 3. I don't recommend waiting till a week before.
Okay, but you can file 4.
Okay.
I don't think you can file more than 4,
Okay.
but you can. Okay, and so let's talk about what you do as a mediator when you have a divorcing couple. Okay, so do you go over all of the Social Security issues when you have a divorcing couple?
Well, let's assume the couple are in their late 30s. No.
Okay.
Unless one of them is disabled or they have a disabled child and there's some relevance that way. But the other thing that I want to point out is that, let's say one of the spouses is disabled and it is, well, they may or may not. A lot of times I see cases where they're disabled, they can't work, but they never applied for Social Security disability. And so they need to do that, because that is, of course, going to impact the calculation of alimony, among other things, right? And if I had one case where the woman did not want to apply for SSI, she didn't have enough work credits to qualify for SSD, because that meant that any alimony received must be in a special needs trust. You cannot, you can't pay alimony directly to someone on SSI, because then if they end up having income over the allowed amount, if it's only in the ballpark of $792, $800 a month, then that will impact their SSI, and you don't want that. So the problem with putting money in a special needs trust is there are restrictions on a special needs trust. A special needs trust cannot pay for necessaries. It can't pay for rent, food, clothing, necessaries. So I do, however, a trust, a special needs trust, can own property and pay maintenance on that property if there's enough money in there to do that. And then that's not considered paying for necessaries, even though it's for the benefit of the beneficiary and they get to live there in essence for free. So,
But let's go to couples.
you need to know a lot about how special needs trusts work. I like to give an example of if you want to buy designer jeans, well, they're certainly not necessary. So a trust could do that. But if you just need a pair of everyday regular jeans, no, that's basic necessaries. That has to be paid for out of your SSI income, which, believe me, is not much money. But a person that is on SSI or SSD will most commonly qualify for a rental apartment that is subsidized, depending on their income.
So let's go to couples, though, that are in their 50s, late 50s, they're in their 60s. Are you discussing Social Security issues?
I am, yes, because I'm sort of sensitive to that issue, given my emphasis on estate and elder law, in addition to my family law practice.
Okay, so what are you telling them, especially in the context of alimony? Say it's an alimony case. So what are you telling them about Social Security?
Well, that's a very interesting question, because I've had a couple of cases where there's language in the agreement about that, that alimony ends when the person becomes eligible for Social Security, or alimony gets modified at that point. You have to, in some cases, you need to specify in the language of the agreement that the person is obligated to apply for Social Security retirement as soon as they're eligible. And you have to clarify, do you mean 62 or do you mean full retirement age? What exactly do you mean, right? So I had a case where the woman was very happy to get alimony of $1,000 a month and had deliberately not applied for Social Security. And when she did, she certainly got the same income of $1,000 a month. And it gave relief to the spouse, because now out of his retirement money, he didn't have to give $1,000 a month, and he needed that money. But the agreement didn't say anything about, just said when she gets it, but it didn't say anything about her being compelled to get it. So you need to be very sensitive to the drafting on this issue.
So, but when you're talking about alimony and you have the needs of the parties, but also then the amount of money they're each getting, are you talking about their Social Security benefits?
If they're of an age where that's relevant,
yes.
Yes, I think
Okay.
it's important. And many people don't realize that their spouse can get spousal benefits with no impact on them. I find many people surprised by that. And also, if you are going to pay alimony, you need, as I said, if they're on disability, it has to go in a special needs trust. You need a special needs trust to be drafted by someone that does elder law, and you need special language in the agreement that incorporates that.
But let's just go back to the divorcing couple. So let's say that the supported spouse, the one who's receiving alimony,
Yes.
you'd list all of her other income, whatever it is. Would you put down for that also her Social Security that she's going to be receiving in the near future, or that she is receiving? So that's part of her income.
Yes. I think you absolutely should do that. And I think that most people haven't been thinking about that, and that very few agreements address that. And, it may or may not make an impact on alimony, but most commonly it does, because therefore her or his need is less.
Right. Now, so if someone is, different question. How often are you seeing that people are equalizing Social Security benefits? so
So
that,
interesting. You said that. It's certainly, I don't know if a judge could order that, but I had a case last week that went in front of an ESP panel. And the facts in that case are that there were a lot of premarital assets that the husband had, and wife had nothing worth, very little, and whatever she had was spent of premarital assets. And so, and they were both over 70, both getting Social Security, and her Social Security was substantially less than his. Her earnings were much lower during her lifetime than his. If you take the 35 highest years in each case, and they're both 72. So how is alimony appropriate in that circumstance? He was working part-time because he was supporting 2 households, which he would like to stop, needless to say. Obviously, I represent the husband in this case. And anyway, the panel recommended an equalization of Social Security, given that she wasn't entitled to his retirement assets because they were all premarital. And that was new to me. I had not seen that before. There was one other case I had where the husband agreed to provide support of $1,000 a month out of his Social Security, but it's supposed to end when she qualified for Social Security herself, or be modified depending on what she got. So I don't know if a judge could order that, but that was suggested by the panel. And then the next question comes up is, obviously, I mean, again, you can see from the discussion of Social Security being taxed, most people that are seeing a private mediator are going to have Social Security and other income in an amount that 85% is taxed. So when you talk about equalizing the benefit, don't you have to tax impact it under the Orgler set of cases? I think you do. And then the second question is, okay, but for how long? I mean, will this person have to still be paying an equalization when they're 100 years old? So to talk about equalization, you need to address those other 2 issues as well, so that everybody knows the full deal.
so, but do you do that? Have you had cases where you talk about those issues and possible solutions? I mean, for example, I've read that some places some attorneys will put into their agreements provisions that will value Social Security benefits like any other retirement, like an annuity or another type of retirement benefit. So look at it like a lump sum and maybe even offset it against other things. Do you routinely do those kinds of things?
I've never equalized Social Security before, but I have this case now that is the settlement recommendation. And now we just have to work out those details of taxation and how long. But I personally have never seen a valuation of Social Security as a lump, where you present value it. I've never seen it used that way.
I say, do you ever discuss that with your clients? Let's say they are on Social Security and there is this rather large disparity, which there usually is, because typically women haven't had either as many years in the workforce, they're 35 years, or they've been earning less because that's just the way it has been. And so there is this unequal part of it. Do you discuss it and what the possible ways of equalizing it or making it more even?
Well, and it gets even more complicated when you think about the fact that Social Security is based on the 35 highest years, and it might be that 30 of the 35 were premarital. So how fair is it to equalize that when a good portion of it is in essence premarital? So it's a very interesting case, and I think that many mediators like myself have become a lot more sensitive to it being an issue and the need for it to be addressed. And aspects of it that do need to be addressed when you are doing that.
Right. I understand that if someone isn't paying their alimony or child support, you can go after their Social Security. Are you familiar with that? Have you ever done that?
I've never had a case where that was applicable. So,
Okay.
I can tell you that Social Security will not allow garnishment, court order or no, you can't do that. So you would have to have some kind of automatic withdrawal from their bank account or something like that. You can't just know that you're going to get it because they're getting Social Security. You can't get it directly. And Social Security will not pay to a trust. They will only pay to a regular bank account.
Oh, well, you know, when I was preparing for this, I did read this one part and I printed it out. It says, first, keep in mind that Social Security benefits are protected for most creditors by strict federal law. But there's one notable exception. Pursuant to court order, the Social Security Administration may take part of retirement benefits for the payment of child support or alimony.
Oh, I had no idea.
Yeah, using this exception and with a full understanding of the Social Security, a couple may make informed decisions about spousal support and equitable distribution and equalize their combined, well, whatever. So,
Oh, that's very interesting. In New Jersey, you can't really, you can't just put like if you're just a regular creditor, you cannot touch retirement accounts. But other states, that's not true. It depends on the state.
right. I also found some standardized provisions that some attorneys have drafted that would go in when you're talking about either equalizing or doing different shares. This would go into the MOU and I guess assumingly into the marital settlement agreement. I've never seen that kind of thing in New Jersey. I haven't seen it very much.
Right.
So I'd be interested if anyone who is watching and either routinely puts in those kinds of provisions or routinely discusses this with their clients would raise their hand. And Terry has raised her hand. I'm going to let you talk, Terry. And if you'd unmute yourself, you can go.
I had a question about a parent who's retired and there's student federal loans that are outstanding. Can Social Security be hit up for that in the settlement?
As far as I read, it was only for child support and alimony.
Okay, because I had someone unrelated to mediation, but an appropriate question for mediation. I come up with a stepchild who forged his signature. And as he retired, he said they were going to go after his Social Security. I wasn't familiar with it, so I didn't say yes or no. We worked on the other issue, but that question remained with me in terms of divorce mediation then.
Mm-hmm.
Thank you.
Okay, now we have some questions that are in the Q&A. Michi says, there is a situation to suspend one's own benefit to age 70 if you're entitled to a widow's survivor benefit. Okay. Joan Geiger says, I never give SSI advice. I let them know there could be issues they should look into and tell them to check with an expert. I don't want to be held responsible for giving wrong or incomplete information. Anju, if you've been married before, will Social Security Agency determine the highest way to claim? I'm not sure what.
Well,
Anju?
if you've been married before, getting remarried ends your claim unless it's after 60. But if it's before 60, that ends your claim to the former spouse's Social Security.
So Anju, why don't you raise your hand and and maybe explain your question a little bit more. Okay. Okay, unmute yourself.
So let's assume that you are now 67, full retirement age, and you were married for over 10 years, and you go to the agency and say, you know, what's the best way to claim? Are they going to automatically calculate it based on either your own earning record or your spouse's? Are they going to tell you how to optimize it?
I wouldn't want to rely on Social Security, the person you happen to get arbitrarily, being completely knowledgeable, or, you know, or they're not, you know, they're not supposed to give you advice, but they are, you know, if you're married, they do, as a matter of course, check which is better, the spousal benefit or your full benefit. But if you're divorced, I don't know if they do that as a matter of course, and it's more important that your clients and you know about it.
So if I were divorced, how would I find out about how much I would be able to collect on my former spouse?
You can
The
call
record.
Social Security and ask them.
All right, and they will give you that information. They won't say you're not entitled to that, or that's a privacy issue.
Well, if you're a former spouse, you are entitled to a spousal share if you were married for 10 years or more and have not remarried before the age of 60.
All right,
So you're entitled to that information.
All right, thank you.
Okay, Michi, if unmute yourself.
Just to answer, Gabrielle's giving the right information, but Anju's correct that Social Security, if you're divorced, they are not going to give the information of a former spouse. You are, when it's time to, you know, first of all, the Social Security website has really great resources, and you can Google all kinds of stuff, and they also give you pretty clear instructions. But Gabrielle's right that if you call or make an appointment, you have to be really prepared and knowledgeable and know your case, because they're not going to know that anything about necessarily your that you're divorced or anything. And if you're going to file if you are entitled for a divorced spouse claim benefit, you have to have like the, you know, marriage certificate, the divorce certificate, all this stuff. The other thing is that, like, for instance, if you happen to be entitled to a you know, divorced spouse, widow, a survivor benefit, you're going to have access to the death certificate and all that kind of stuff, aside from the marriage certificate, the divorce certificate, everything. You have to prove your, you know, what your situation is. And Gabrielle's absolutely right. The person you get on the phone, you can't assume. It's like any customer service. Nobody knows everything. And, you know, they've got this enormous manual that they're working from, but no, there's no way they know, any one person would know everything. But the website has so much information there. So.
Okay.
Agreed.
Anju, your hand is still up. Do you want to ask another question? Anyway, if everyone who has raised their hand previously and does not want to ask another question, please lower it. Joan? Joan?
She did. She lowered it.
Oh, okay. Now it's back up again. Do you have a question, Joan?
You have to unmute yourself, Joan.
No, I don't have a question.
Okay.
Okay. Anju put into, well, she said two things. One is, Gabrielle, if you take down your screen share.
Oh, that's a good idea. Thank you.
Yeah. And the more substantive one is that Steve Abel has an article about equalizing Social Security. And what can I do that? If you would, Anju, if you'd put that into chat, that would be good. And then people can see that. I don't know if they can see these Q&As. Okay. And you say you're looking at a blank screen. I'm not sure what you mean, if that was on screen share. Okay. So there's the article in the chat for the Abel article on equalizing. It appears a lot of things that I saw when I was doing research for this about Social Security and equalization and that kind of thing were New York cases, surprisingly, or from New York attorneys. And I'm wondering why that is much more prevalent, both being discussed by mediators and them actually doing something in New York. I mean, it shouldn't be, but it apparently is. So let's see, do we have anything
Carl,
else?
could you email the people that were on this webinar and maybe send them the clauses you found? That might be helpful to a lot of people.
Sure. Yeah, I can do that. And let's see, is there anything? Okay, looking at Bland. Adam Berner. Keep in mind that Steve Abel's article was written a long time ago, and I don't think it was updated since the law changed in some regard to these issues. Adam, if you raise your hand, then maybe we can see why, what you mean by the law has changed in that respect. So let me see. Adam. Okay, Adam is not raising his hand. So I'm not.
Well, you
quite
know,
sure.
they used to have a thing where once your spouse could, the high earner spouse or older spouse could request Social Security within a year, change their mind, and the spouse could still get a benefit, but the other spouse, but that went away. That the law changed on that. It had, you know, it's different criteria now, and it's much more limited.
Okay, Anju, did you have a comment on that?
Yes, so Steve Abel did give a presentation to NJAPM at a general meeting 15 years ago. And the way that he would equalize it would be through, let's just say the husband was able to collect $3,000, the wife was able to collect $1,500. The husband would make a payment of alimony. This is when alimony was taxable to the wife of the difference, the $750, so that you would have an equalization. Now, with the change in the federal taxes for alimony, that would change, but that's how he was doing the equalization, through an alimony payment.
Okay.
So that's my understanding. And I, you know, maybe, and I think Steve, this became his reason for living, to, so to speak, the idea that this Social Security is a vestige of our, you know, of a sexist society. I think that was the name of his article that he had years ago. And he also had this in the Friendly Guide to Divorce that a lot of people use. So I think that guidebook became, you know, a touchstone document that people would look at. But that's my understanding. I've only done this equalization in a very long-term marriage where the parties were in their 60s and they were coming here and the wife had not worked outside the home. But I think that case that I did was over 20 years ago. And I'm not the expert that Gabrielle is in this area, so I try and stay away from this topic.
Okay.
Thank you for allowing me to speak.
Well, Adam has said that he's not ignoring us. He didn't raise his hand and he can't speak on the computer he's on, so that's the problem. Michi says, one point to remember is that the benefit estimates listed on the Social Security statement assumes that you are working with the same salary up until you start claiming.
That's true.
Okay.
So obviously it will be impacted if you get increasing pay over time or decreasing.
Okay. So I would be interested in, again, of the people who are watching, how many of them in older couples routinely discuss Social Security and put some sort of provisions into their MOUs? Is there anyone who does that routinely? I know Joan says she doesn't talk about it at all, but are any of you doing that? Okay. Joan has her hand up again. Joan?
Hang on, I talk about it. What I won't do is if I won't tell them this is what Social Security will or won't do, because I don't want to give bad advice. I frequently talk about it, especially when they're older. And I tell them, you know, go ask Gabrielle or go ask somebody that knows a lot more about this than me, and then come back to me and tell me what they said. And then in my agreement, I will put, that they consulted with an expert, and based on what that expert told them, they've agreed to do X, Y, and Z. Because I don't want the responsibility, like Gabriella said, it's way too complicated. There's way too many laws involved. And I don't know what the changes are and what they aren't. And I don't want to become an expert in it.
Okay.
Good point.
I like that, yes. Okay, Linda Spiegel, unmute yourself and ask.
Hi, basically what Joan said, because I also do estate planning, and I've had the occasion where I've had, like Gabrielle has, you're doing estate planning for clients, you find out how old they are, you ask what their social security income is, and they look at you and they don't even know what you're talking about. And I've told them exactly the same thing, go apply for social security. And I do have an expert that is in the, works for Morgan Stanley, who I've had speak at a number of meetings all about social security. And I've referred people to her, in terms of divorce mediation, or whether it was divorce litigation, to find out exactly what the story was. And like Joan, then come back and then we can incorporate it into the agreement. But it's not amazing. I mean, those of us who've gotten to retirement age, I went to seminars, as many as I could find, all about Social Security, just to learn. And a lot of people don't do that, in advance of getting close to that age. But it's real important, and you need to understand it. And there's can be money lying on the table that can be very useful.
Okay.
And there are people that are, and it's not me, that are actually certified Social Security experts that, go through training and take tests to get that certification.
As a matter of fact, I'm in Bergen County, and the county does seminars, and you can also, through their senior program, call and find out, and there are people there who are certified who will help you with that.
Good information. Thank you.
Okay, Anju, you have your hand up. Where are you? Okay.
I didn't actually mean to have my hand up, but I asked my clients to make an appointment to go talk to Social Security about their options and then come back. Because if they're trying to plan, what they're going to have, they need those numbers. Right? So even if it's not that there's going to be support or there's going to be an equalization, they still need that information.
Right.
And I am not the expert, so I don't claim to be. I'll put my hand down.
Okay, thank you. Okay. Any other questions? Any other comments? Anything in Q&A? Seeing none. Gabrielle, I want to thank you very much. It was very informative. And I only wish I were still practicing so I could use some of this. So in any case, thank you very much. I think everyone enjoyed it. And oh, that's Terry also saying thank you very much. So let's see, our next webinar is going to be on November 1st. And it is going to be on retirement assets and divorce with Amy Wexler and Judith Deere. And Judith Deere is, let's see, she has her own Quadro firm, which is called All Pro Quadro LLC. So we'll be talking about Quadros, obviously, and other retirement assets, and it should be really very interesting. So that's a CLE one. So don't forget, you'll have forms, et cetera, to fill out, and you can still get a pay for the 10 webinars for CLEs and go back and look at the ones that are now recorded and available on the YouTube channel. So you can always, if you miss one, you can always go to the YouTube channel, watch it, and send in the required forms. So with that, thank you very much, everybody. Thank you, Gabrielle. It was really great.
Yeah, I enjoyed the participation. Thank you.
Okay, have a great day, everyone.